I still want to talk about ARIPO, the African Regional Intellectual Property Organization. It has its origins way back in 1976. It was known as the Industrial Property Organization of English-speaking African countries, ARIPO. The reasons why it was created was basically to pool resources in managing intellectual property. There was a collaboration between the United Economic Commission for Africa and the World Intellectual Property Organization. And they created a secretariat, initially temporary, then a permanent one at Sheria House in Nairobi. In 1982, this organization started growing. So they looked for more suitable accommodation in Zimbabwe. It has been here since then. In 1985, other African countries were permitted to join the organization. Basically, any country that is part of UNECA or OAU then, which is now AU, can join ARIPO, and that's why we have now in our membership, we have Portuguese-speaking countries and others who don't speak English. So the name changed from that time. We lost the English-speaking notion, so we became ARIPO, but dealing with industrial property. In 2002, we were given a new mandate, that of copyright. So we covered the whole package of intellectual property, and the organization was renamed. The abbreviations remained the same as ARIPO. The primary objectives, as I indicated before, was to try to find some approximation. They called it harmonization, but I'm sure the lawyers in the house will tell me it's not possible to harmonize laws among sovereign countries. So they tried to develop some approximation of convergence in the intellectual property systems among the member countries. ARIPO also established common services and organs that would be used to develop management of intellectual property, and also to develop those systems within the member states. A primary objective at that time, because up to now we don't have a lot of human capital that we can say is very competent in dealing with intellectual property. So one of the many mandates is to develop intellectual property, human capital, and to promote the linkages between research and IP. So briefly, that is the introduction of the organization that I work for. We have our headquarters in Harare, and we have an establishment of under 100 people. So KIPI is actually slightly bigger than ARIPO. My official title, as Fred had indicated, I work from home but live in Harare. So as you can see, I'd intended to talk about filing and processes in here, but we had a brief discussion with Fred and we moderated the agenda for today. So if there's anything that I may leave out, you're free to remind me of the fact. So one way in which the regional organization manages intellectual property is through protocols. The protocols are agreed upon by member states, and each member state has to actively be party to a protocol before it can be applied in their territories. So with respect to patents, industrial designs, and utility models, we have the oldest protocol in ARIPO. It came into force in 1984. It's the Harare Protocol, concluded in Harare, as the name suggests. It allows the ARIPO Secretariat, where we work, to process and register patents, industrial designs, and utility models on behalf of the member states. But the second paragraph is very important, especially when towards the end of my presentation, I will briefly kind of avoid talking about enforcement, but we realize that every right that we confer on behalf of the member states immediately becomes an equivalent right under the laws of the member states. And if there is anything to do with enforcement or contest about it, it's subject to the member state laws. So, briefly speaking, if an application came in the right format and with the right content, it should be a fairly straightforward affair with us. We, of course, are hoping that each of the 4 stages that we have outlined here will, will have its requirements met. The requirements are stipulated in the protocol. So there are requirements for being accorded a filing date, for example. There are minimum criteria that an application must meet. And I'm happy that the audience is largely people who want to be managing these processes. So there are basic filing date requirements. And then there would be formal requirements. After filing date is granted once we see at face value, we have an application that seems to have a request. It seems to have a description. It seems to have at least one claim. Then after seeing that, it goes to the next step, which is a formality examination, where we check that what was presented, does it have the physical requirements we expect? Is what we were thinking is a claim, for example, a real claim, or is a political statement somewhere? After that, if it meets that requirement, we now look at the substance of the claim, of the disclosure. And I will go into details about what a disclosure is in a while. The substantive examination determines whether the application may be granted as a patent according to the protocol, which is an approximation of the member state laws. Of course, there may be slight variations, and that allows us, after substantive examination, to inform the member states that we intend to grant this patent. It's claiming ABCD. If they are not comfortable with it, then they will tell us that no, we cannot allow you to grant this on our behalf, and they have to do that within 6 months. If they don't do that, we proceed to grant registration and publication. So basically, what I will talk about is how this process is undertaken within our office. Within the protocol, we expect that residents of the member states or people who have effective business presence can represent themselves directly, either before us or before the IP office of the member state. So if they are in Zimbabwe, they'd go to ZIPO. If they're in Kenya, they'd go to KIPI. And KIPI effectively becomes a receiving office for us. The applicant can go directly, or he can choose to appoint a representative who has to be admitted to practice before the national office. So if you're in Kenya, you must be an agent admitted to practice before KIPI, before you can be authorized to represent an applicant. And any applicant who is coming from outside the member states must be represented. We do not correspond with applicants from outside the member states. We accept most forms of communication for filing, but we cannot insist that when an applicant goes to the national office, he has to file according to the format that the national office allows. I have highlighted in this slide online filing because it's something we are trying to promote and we have realized is very useful. Like now, when COVID came, we are working at full capacity because most of our clients are able to do online filing and we process them online at home. So there's a very minor impact of COVID in our operations. And when we started it to encourage applicants, we even gave a discount when you file online because we don't have to recapture your information and so on. So having seen where to file, we now want to see what makes a patent application, and I'd hasten to add that the specification that makes up a patent application is the same as what makes up a utility model application. We expect a request, an indication that the applicant is seeking patent protection, plus bibliographic data on who the applicant is, generally the area, the title of the application. And because we work on behalf of the member states, they have to tell us at least one member state where they want to seek protection. A patent specification, therefore, would have 5 documents. And there are 5 documents, as in you don't, when you're through writing one, you don't continue on the same page with the next document. So the first document is the request, which is a form normally issued by the IP office. In our case, you can always download it from our website. The second document is a description. The third document is a set of claims. The fourth document, which is optional, would either be drawings, graphic illustrations, or if you are dealing with certain branches of science like genetics, a sequence listing. And then the fifth document is an abstract. I will define each of these, hopefully, within the time allotted. All applications are subject to payment of the prescribed fee, but historically, we have always provided that an applicant can indicate that he will pay within 21 days. And in that case, we begin the processes while waiting for the 21 days. So I indicated before that to get a filing date, we need the request, a description, and at least one claim. In our case, once we see that, we will notify the applicant and the designated states. These are the states, the member states where the applicant indicated that they wish to seek protection. We use a form, it's easier and the communication is very accurate. If it doesn't meet the filing date requirements, we will notify the applicant using the other form, that is Form 11, and invite them to comply with the missing requirements within 2 months. Once the filing date has been allocated, then we go into formality examination. Again, we double check that the filing date was actually met, because probably this filing date was, the application was received in a member state office, And during transmission, some bits of paper got lost. So we ask, maybe no claim has arrived. We ask for the claim and so on. If the applicant talks about drawings in his description, but we are not seeing the drawings, we will ask for that. If some details about the bibliography or designation are missing, we will ask for them. Generally, because we have a diverse membership, it's possible that the original application could have been filed, for example, if it's in Mozambique in Portuguese. And by the time we are looking at formal requirements, we expect an English translation to have been furnished. By that time, or at least within the 21 days, the fees that we said you could undertake to pay, we expect it to be paid. The physical requirements are stipulated: the margins, the line spacing, character size, the nature of drawings. We expect a conformity to all those. Once the application meets those requirements, then we look at what you could call the history of the application. If it was a Paris Convention application that came directly to us, and the applicant claimed priority of an earlier filing, then we expect details of the priority and actually the document to be filed. If the applicant is represented, then we expect a power of attorney, officially appointing the agent. If the applicant is not the inventor, we expect some indication of assignment. Once the application meets all these requirements, then typically we would notify the applicant and each designated state that an application has been filed that meets formal requirements. Again, we use a standard form. Otherwise, we invite the applicant to remedy any shortcomings. So once the formal requirements have been met, and for patents, the applicant has requested for examination. For utility models, there is no requirement for the applicant to request for substantive examination. So once the formal requirements are met, we would typically just proceed to substantive examination. But once these requirements are met, we now present the application to a substantive examiner. And the distinction between utility models, because I'll probably not revisit it again, and patents is really simple. One, the requirement for novelty or the newness of the idea that has been reduced to practice is universal if it has to get patent protection. For utility model, we only look for regional novelty, meaning that something, if we can, it's not registered among the member states or in our database, then we consider it new, even though it may exist out there. Patents would require an inventive step. That is, the idea is not obvious to professionals working in that field. And the third requirement that is common to both is it must be a useful idea or industrially applicable. So we typically undertake examination. We don't grant patents which have not been examined. There's one distinction between us, and perhaps you're aware, there is a regional body that has linkage to Francophone Africa, where they used to register, but now we are harmonizing. So in good time, they will also go to examination. So in order to conduct examination, we must do a search for novelty. And we prepare a report for the search. Then we do examination and we prepare a report for examination. We consider a lot of things besides the obvious three, that is novelty, inventive step, and industry applicability. I'm starting with this because as an examiner, this makes my work slightly easier. If I look at the application and I see there's non-patentable subject matter, perhaps there's no need to now analyze it for other criteria, and my work stops at that. If you have not disclosed, and this is a very important point, I don't know how vigorously I can emphasize it, especially to prospective agents. The application must be disclosed in a clear and complete manner that would allow ordinary practitioners of the trade to work the invention. If you are making the next generation iPhone and you are seeking a patent for it, then anybody who can manufacture phones reading your disclosure must be able to make the exact same phone without coming back to you to ask any further question. So if I think your disclosure is not clear enough, I raise it as an objection. I'll be resting for a few days waiting for you to address that. If the disclosure may be complete and clear, but what you are claiming from the disclosure is not clear or fully supported, the legal requirement is that the claims define the subject matter to be protected. They must be clear and concise. Somebody cannot read a claim and have more than one possible interpretation. Clear, concise, and it must be based on the description. You cannot claim what you have not disclosed. So if I think parts of the claims are not clear, and perhaps arising from that, because what we actually examine are claims, I will probably talk at length about claims. If I take too much time, the moderator will tell me to move on, I hope. But claims are what we examine because they are what define the scope of protection that your patent confers. So this is just reciting what I was saying, clear, concise, and supported by the description. So once in a while we see an applicant telling us that is claiming an apparatus as herein described with the help of appended drawings. The description plus drawings is 10,000 pages long. How clear and concise is that? So a claim like that, definitely we will object against it and not render any opinion about its patentability. Because when we look at a drawing and a description, what I can read in them is not exactly what you will read in them. So it's not possible to determine the actual scope of protection given by such a claim. Other areas that we normally object to is when somebody says a comparative expression without providing the baseline. You say something is long compared to what? Or thin or fast. A fast chameleon would not be as fast as a rocket. So you cannot compare without providing the bounds of what you're comparing. That would be unclear. There are instances, and I hope nobody will take it that I have anything against lawyers, but lawyers do not like being precise most of the time. So he will talk of and or, and a series of features such that by the end of the sentence, you don't really know what exactly is being claimed. Typically, we will object to such a claim. And support by the description. You cannot disclose one item in a very big set and then use it to claim the entire set. No. Then other claims introducing sub-features related to the main feature are called dependent. Now, this dependency can be very convoluted until you don't know what exactly is the features being claimed or not claimed. Under the protocol, we do not allow a claim that depends on more than one claim to be the basis for another claim that depends on more than one, just to be clear on what exactly we are protecting. The number of claims are expected to be reasonable. Typically, we've seen cases where, because we indicate that the scope of protection is determined by claims, an applicant would give us 3 pages of description and 30 pages of claims, whereby the claims are not even related to the description. So in that case, outright we say the claims are not reasonable, given the disclosure that came with them. We expect the claims to be logically grouped in terms of the major features that they relate to. And I've talked quite a lot about claims without defining what it is. This definition is not standard, so don't take it to be the gospel truth, but it helps me to determine what somebody can claim from what he cannot claim. Because to me, it's a statement of the technical improvement that the applicant has made to the state of the art. And it defines the technical aspects over which he is seeking exclusive rights via the patent protection. The requirement under the protocol is that at least one claim must be present before a filing date can be assigned. And it's one of the 5 subdocuments I talked about that make up a specification. The document listing all the claims is called a set of claims. And each set of claims can be amended anytime by a replacement. It's not that you come to the office and quote what you want and leave what you like. So in a real world situation, we look at claims as a definition of the exact map of your improvements to the general body of knowledge known to mankind. And that body of knowledge is made up of what is in the public domain, that is prior art that has been disclosed and nobody is claiming ownership.
Remember, he has mentioned that you cannot have a very brief description, 4 pages, then you come and claim the whole world. You claim, your claims are like 15 pages. The examiner will immediately notice that you are over-claiming. You're claiming what you have not described. So chances are that most of your claims will be rejected and therefore your patent. So the main issue here is that you must describe more than you claim, so that in case they reject what you have claimed, you can go back to the big dossier and fish out if there is something you can claim, so that the patent can be issued on new claims. You can see it's now joining us. So, yeah. Okay, welcome back.
Sorry for the so many disruptions. I hope I'll be able to conclude faster now.
Yeah,
Uh,
yeah, proceed.
so
Sorry.
yeah, what what I listed here are examples of how claims would require or create a connection between the different technical features that make it make sense. Uh, for example, this is a racket, but typically applicants like being vague about what they are applying. So they are talking of a game device with the handle head portion connected to the handle and a protrusion secured to the handle. This still is a very vague claim because if I was trying to sketch what the applicant meant, probably had not come up with the racket. Very often we have to raise clarity objections when such claims come. So there are other ways of expressing claims. Typically, this is a way of expressing a claim that relates to what we call knowledge economy inventions, so to speak, or inventions in areas that are fairly crowded, so that the claim may be very long, list a very long, large number of features, and the applicant wants to help the examiner by pointing out the exact features that he considers an improvement. It's typical with certain types of American applications directed, say, at business methods or in ICT. So if we were to apply it to a real life situation, then we could look at a situation where the racket we looked at has an improvement of a protrusion secured to the handle. So when the examiner looks at it, he doesn't object to anything coming before the wherein the improvement comprises of that. If that was an independent claim before us under the protocol, we would object because we expect a claim to be in a distinct two-part form, which Rule 7 says there's a header that is very distinct. It talks about all the features that belong to the prior art, but that you need to define what you're claiming. Then the transition between the header and the character or the subject matter claimed must have a recitation of an expression to the effect of characterized by. Then now whatever comes after that, we expect it to be new, inventive, and industrially applicable. So we can have the same claim. The character is as a protrusion secured to the handle. And there is also a certain category of claims where somebody defines means and function. But again, with this kind of claims, we often raise clarity objections because when you say means, how well defined is this means? Because sometimes the applicant just means for doing this. As we can see in the next examples, we have means for holding rice and a heater configured to heat the rice. This means for holding rice, is it by hand? Is it by some pot? Is it by inside the typical rice cookers that are purpose built? With respect to the protrusion that was attached to our racket before, somebody can decide that it's something that stops it from slipping. So there's a anti-slippage means secured to the handle. Now, do we have a very good picture in our mind of what this means is? Typically, when you say the means, it makes the claim very broad because this means can take any shape. You talk of a heater, for example, in the first example. A heater could be using firewood or charcoal or electricity or gas or just a heat exchanger. So what kind of heater are we claiming? So again, now this is probably language, and given that my background is engineering, I may want to skip this. There's a specific punctuation that we expect for a claim. As we saw, it's one sentence. It has a preamble, a transition phase, a number of elements, and you could have among that number of elements, specific elements that you wish the examiner to look at. You identify them by indicating that they characterize your new improvement. So we have a few examples. This is still the same book we looked at. It has a binding configured to hold printed pages and a cover that is detachable from the binding. So what the applicant is actually claiming is the fact that the book cover can be detached. The rest is just to explain to us what the area of technology where he's created a new development. When writing the claim, even though we are scientists, we try to learn to speak proper English. So if somebody had not introduced something before, we don't allow them to talk of it in the definitive form. If you are talking of an engine, the first time you introduce it, you'll have to use an indefinite article to define it. It's an engine. Later in the set of claims, you can talk of the engine, now referring to the engine that you introduced probably in claim one. Typically it looks petty, but sometimes you'll realize that somebody is claiming more than one engine in the set of claims. And when he realizes that one of the engines is not actually going to cut the criteria, then he switches that he had different engines, not one. So you have to consider that what he's telling you is what he means. If he has one engine, it should be clear. If the previous claims define more than one engine, then there has to be a way of identifying that there are different engines. Again, these are points of grammar, but it can lead to a rejection of an application because we would say it's not clear, it's indefinite. Again, this is practiced before ARIPO. It's not a universal requirement, but we believe that if features of an application are illustrated with drawings, then it's easier for somebody to conceptualize what is being claimed. If the features that have been described with the drawings, probably labeled, have the reference signs also included in the claim. We have to be careful that we do not refer to drawings as such. If you have one drawing, say figure one, it has maybe 10 features. And one of the 10 features you have labeled item 6 is a boiler. Then whenever you mention the boiler in the claim, then you can have boiler, then you have brackets, 6. Then you continue describing the others. But you cannot tell us to read the claim and as illustrated in the drawing. Maybe I don't want to read the drawing. So when I read the claim has to be self-contained. And the reference to the drawing is limited to just having the signs that define specific features that have also been described very elaborately in the description, inserted in the claim, to help somebody read that maybe you had 10 boilers. So if you have boiler 6 following 16 following 26, then you can say boiler 6 is placed after boiler 16 and so on. It helps somebody to conceptualize what is being claimed. I said that we look at claims as a set. And in the set of claims, there would be independent claims that introduce major features. And with respect to these independent claims, I may want to introduce another requirement that relates to unity of invention. So typically, one patent is issued for one invention. It's not a big problem when drafting because you will always be notified if there's a perception that the inventions are not related, that you'll be invited to split the application into several uh, applications, each representing one invention. But then now the broadest claim that more or less outlines the whole invention, whether the invention is a product or a process, is called an independent claim. Then other features that give details about this invention may follow it. In observing the unity of invention, we expect typically, unless we have what we call related inventions like an electrical socket and a plug, obviously they always work together. So you can expect somebody to invent a plug and also invent a socket that works with it. Besides that kind of applications, we expect one independent claim per invention. So one independent claim means that you can have one product claim and one process independent claim. So we have two of them. If you can show that use of maybe a new product, typically in pharmaceuticals, then there's a possibility of having product, process, maybe of manufacture and use. So at most 3 independent claims. Anything beyond that would make us start thinking of lack of unity. So having listed the main features, you can have any number of sub-features that relate to the main features that have been listed. So the sub-features are defined by dependent claims, which include all the features of the parent claim plus additional details that maybe fine-tune the feature to do or to work in a certain specific configuration. Typically, we consider that they narrow the scope of protection because if you are claiming, for example, the first claim is a structure made up of metal, and now you are going to very specific, it's made of aluminium. Aluminium now is a narrower scope, and typically it's considered a fallback possibility when we object to metal because somebody else claimed another metal, maybe iron. Then if you had aluminium, you can now promote your aluminium claim. Maybe it was claim 6. You promote it to be part of claim 1, that feature of aluminium. Now instead of metal, you just claim aluminium, or you say metal, but later you say specifically yours is aluminium. Then there's a possibility if somebody was working with iron, he's probably not working with aluminium. So when you fall back to that, you are whole claim, now claim 1 with the narrower scope, is considered novel, and then the other procedures will follow. This is an example of the racket invention, and we have a set of 3 claims. We can see that the protrusion we were talking about is a grip that receives the hand of the user. Again, you can see that claim 2 has all the features of claim 1, but there are further details that are not necessarily part of claim 1, and so on, as you continue. So this is another categorization of claims, which we have talked about, but there are specific ways in which biotechnology claims are written, or software claims, if they are patentable within the jurisdiction. Under the protocol, software as such would typically not be patentable, but if it's integrated in something that offers a technical solution, it would be patentable. We have what we call omnibus claims, which are also not allowed. A good example is what we saw as a bad example, actually, where somebody is saying, as herein described with the help of attached drawings. That covers everything that is described, and it's technically not a claim. We have looked at means plus function, but there's a variety of that. That is a step plus function. If somebody had a step, this is related to a process mainly. But again, the step must be sufficiently defined to be uniquely identified. We see like a step for converting. This step is not very specific. The step is not very specific in this case. So unless it's defined maybe in an earlier claim, we would obviously object to this kind of structure.
But I have a procedural question.
Okay. Coming in.
Yeah, may I go ahead?
Please go ahead.
I was asking, because I saw in one of his slides something to the effect that once you file, you wait for 3 years before they do the examination. Like, why such a long period? Because I think even yesterday I had an even longer period. Is it 7 years?
5.
I don't know.
Yeah, welcome back. In Kenya is 5. In ARIPO is 3 years. That's the end point during which you must apply for examination. So maybe Fred, welcome. Continue, take it up from there. Why should you give people 7 years to examine or whatever? I don't know, or to apply for examination? Or 3 years.
These are typical examples of very simple claims. Somebody wants to cook rice, then the preamble of the claim would talk of an apparatus for cooking rice. If he wants to cook other grains, he'll talk of other grains. If it's cooking in general, he has to talk about cooking in general. Similarly, he could be talking about the process as well. And the process has to relate to what was in the title of the invention. Then typically, we would not look at the preamble unless it was really misplaced. but we would begin looking at the transitional phase. That is what joins the preamble to the body of the claim. So if you have an open-ended transitional phrase like comprising, including, containing, or characterized by, it just means that one of the many features that what you're claiming may have could be what you have listed, but your list is not exhaustive. On the other hand, if you say comprising, then we assume it's a closed list, so that if what you are making up was maybe a formulation, then what you have listed must make up 100%. And typically we would object if it doesn't do the same. Just emphasizing what we have just seen about consisting. In this example, we have a book. Somebody was claiming a book as an apparatus with pages, binding that holds the printed pages and a cover attached to the binding. As you can see, all those, they make a book, and there's nothing else beyond that that makes a book. I hinted at percentages that have to add up to 100% if it's consisting. Then the most important part of the claim, that is the part that outlines the features, the technical features, which we often call limitations. Limitations because we remember the boundary map that we had seen where somebody is taking his claim. So they are the limitations of what the body of knowledge, what part of the body of knowledge available to mankind would be available to people generally, and what would be exclusively belonging to the applicant. Typically, we expect, even if we are defining a product, but the parts of the product must be connected in some manner. It's not just a list of products that do not seem to have any functional relationship. And a very easy example here is a table made up of one leg and a top that supports at least one of the legs. So we know there's a support relationship between the leg and the top. There are easy ways of, or what typically leads us to suspect that there's no unity is we have very many independent claims. Sometimes just by looking at the claims, we can see the features are not related. But sometimes we tell that after beginning some kind of examination, as in we realize that the common technical feature between different sets of claims is very well known. So we raise that objection that this common technical feature is not special, and advise the applicant to divide. So I've more or less defined the patentability criteria. The novelty, it's new, it's not part of the prior art, it's not obvious, and it's useful. I defined the distinction with utility models. I hope we'll remember the regional novelty, no requirement for inventive step. And for novelty in practice, when we are examining, we try to compare one application with one citation in the prior act or one publication of a patent or a scientific document. And if all the features claimed are present in the citation, then we would object to novelty. So it's a single document that has all the features. It may have more features than what is claimed, but it has certainly all the features of a claimed invention. With regard to inventive step, we may combine documents, or we may combine one document with what is considered common general knowledge in the art. And we typically use what was developed by the European Patent Office, which is a problem solution approach. We ask ourselves, like in my case in engineering, if the problem that is solved by this claimed invention over and above what was known at the time it was created, were presented to an average engineer who is not inventive, would he come up with the exact same solution? It doesn't sound very objective, but there are steps that, if analyzed critically, would make it objective. So that, plus the other criteria, unity of invention, subject matter, whether the working of the invention would not be objected to by any law in the member states. Once we've done that, we write a report. If we are convinced that the applicant needs to rectify some features of the application, we send objections with details through a Form 18. This form would be accompanied by an examination report and a search report. If we are convinced that the application may actually proceed to grant, then we write Form 21, notifying member states as well as the applicant. The member states would have 6 months within which to raise any objections to our proposal to grant. And if there is no such objections, then we proceed with grant and registration. The patent gets published, and it's enforceable in each member state designated according to the laws of the member state. As part of the harmonization, the member states have agreed that patents granted through our system would last for 20 years subject to maintenance, and utility models would last for 10 years subject to maintenance. Enforcement, again, I'm repeating that it depends on the laws of the member state. And as of now, Harare Protocol has a membership of 18. There's 18 members of ARIPO. Somalia is a member, but is not yet part to Harare Protocol. So as a means of improving the ecosystem, we try to adopt whatever we consider is progressive elsewhere out there. So lately we had amendments to parts of the regulations and the protocol that allows reestablishment of rights where the applicant maybe did not intend to lose the right. Then within 1 year, they can apply to have it reinstated. Sometimes the applicant, occasionally they say they're not aware that they're supposed to, for example, pay maintenance fee or request for substantive examination within a certain period. Or in case we write to them with the Form 18, that they have a specified period within which to respond. So if they can prove that they genuinely did not intentionally lose their right, they typically reinstate the right. We also came across several requests that applicants wanted to limit their claims. Maybe it would avoid conflicts in the market with other players, or it would avoid conflicts with their own other patents. So they may want to further narrow the scope of their claims even after grant. We allow that it's only to further limit the scope. We cannot amend it to maybe widen the scope. The other post-grant activity that we do is keep a record of maintenance and a register of all the rights granted. Hopefully, the disconnections did not get us too far off track. I hope to stop there.
Thank you very much. This clap for Miti. So that's why we have Zoom anyway. You've done a good job, I think, within the timelines, and the apologies for interruptions. So you may look at questions. I think some were being thrown to you privately, some are through everyone's whatever chat. Respond to some or not all, and invite people. Maybe you can control that. You can invite people now to give their concern. So maybe start with the ones you can see as people compose their questions or discussion from the chat.
I'm not sure I'm seeing the whole chat. I'm only seeing what you posted.
I remember. Okay, because every time it went off, it went with the recording, the video.
Yeah.
Okay. I think let's invite members to try and recollect their questions, and then we start discussion. So the floor is open. Anybody who is ready? Okay, but you can see everyone at least. Engineer, you can start with the general one that you can see from the chat. Because most of mine were comments. I was taking notes just to make sure that when I'm compiling, I remember. For example, the novelty, I think we agree it's limited to regional. So you could elaborate on that. What do you mean by a regional novelty? And then this other question is, no, I was asking them to post. Then I made some notes. So, okay. Anybody with a question?
A question from me.
Okay.
Yeah, Fred, thank you very much for that presentation. It was wonderful. We never mind about the disruptions; they were not yours. Now, there is something you said about an applicant for a patent should be from a member state. You said that, right? Did you say that?
I said an applicant from a member state can deal with us directly, but
okay,
from outside, yes.
Okay. Now the question I have is, when you say an applicant from a member state, an example would be where a Kenyan resides and works in the UK. If he makes an invention and he would like to make a claim here, well, by here I mean in this region under ARIPO, would he be considered an applicant from a member state? He made the invention in the UK. He's a Kenyan, but he works in the United Kingdom. That is one. Yeah, no, the other one was answered by Fred when you're away. So I've only that one question.
Okay, thank you. So do I take?
I can ask a question.
Okay.
I've posted it on the chat, but it regards an assignment. So if you have filed a patent through ARIPO and designated several countries, when filing an assignment, does because I know you have to enter a national phase. Yeah, I'm assuming the process is the same as a PCT. So once you have done that, if you want to assign a trademark, I mean a patent, do you have to file national applications, or one application through ARIPO will act to assign the patent in all the designated countries?
Let me get your question clearly. Let's say A owns a patent and wants to transfer ownership to B. Isn't that what you mean by assignment?
Yes, yes.
And okay, ownership can be transferred territorially. So he can choose to transfer in all member states, in which case they'll use ARIPO, or you choose to transfer in each member state, in which case they'll go to individual IP offices.
Okay, so you don't have to file several applications as you to each country. So one application through ARIPO is enough.
If you're transferring if you're assigning this patent,
yes,
with respect to all the designated states.
Yes.
Because you recall ARIPO only has one certificate.
Yes.
So if you are designated 10 countries and you want to assign in all the 10,
yes,
then you can do that at ARIPO.
Okay. Okay. Thank you so much.
Okay.
Yeah.
So that is one question done.
Just a follow-up on that. Oh,
okay.
Sorry. Just a follow-up on that. Yeah. You see, ARIPO issues one certificate, and this certificate is kept with ARIPO, the copy, isn't it? The certified copy is with ARIPO. Now, the applicant wants to assign to only 3 territories, maybe Uganda, Kenya, Tanzania. You are saying he goes to Kenya directly patent office, or he goes to ARIPO and ARIPO says, okay, divide this certificate into various portions. How does that work?
No, ARIPO does not divide the certificate. He'll assign it in the different countries. And once the process is done at the national office, they'll just inform us so that our register says the Ugandan rights to this application belong to so and so. But the assignment is done in Uganda, Kenya, or wherever.
Oh, okay. They just notify ARIPO that change the records to ownership to read C, D, E. Okay.
Yeah.
Good.
So do I take the other question?
Proceed.
Okay. If normally, like I said, the patents are used in business. So if you're a citizen of, say, Kenya, and also a citizen of the US, because I know Kenyans can be citizens to more than one country, do you have an effective business presence in Kenya? That's what we look at. We don't really look at the citizenship. No, we look at having an effective presence, so that if we are corresponding, we can correspond with you, and you'll respond without necessarily requiring help. That's what we look at.
But maybe I don't. Sorry, Bonomiti. I may not be having a business in Kenya, but I have got a patent agent in Kenya. Then
actually, if anybody from anywhere in the world can be represented by a patent agent before ARIPO, provided the patent agent is from one of the 19 member states.
Okay.
So if you are an American, you can have an agent from Kenya, from Malawi, from Ghana, from anywhere.
So you're saying the applicant does not have to have a business presence in Kenya. So long if he has an agent in Kenya, that will do.
Yeah, that will do.
Thank you very much.
And actually, statistically, close to 90% of what we do is applications by foreigners, and they come through those agents. Yeah.
Yeah, a final question here. So if I want to be, we spoke yesterday. We spoke about being a patent agent with KIPI. Now, if we want to be a patent agent with ARIPO, we need to do separate applications, or if you are a patent agent?
No, the only requirement is that KIPI has admitted you as an agent.
Okay.
All our agents are those admitted by the national offices.
Okay.
Yes.
Thank you.
So the other concern was regional novelty, if I'm not wrong. And regional novelty, we were looking at utility models as an entry point for our local innovators who may not be very skilled in even drafting their specifications. So it was one way of encouraging them to acquire rights to their innovations. And innovation sometimes by the local innovators could involve a lot of work, but it's something that has been done before. So we were seeing that a utility model doesn't last that long. And as a means of encouraging local innovators, we only try to avoid conflict between rights within the region, but we try not to look too far outside. So basically, in practice, what we do is we look at our register. And if we don't find something that somebody has applied for, we propose to register it as a utility model. We do not have access to the national registries, but we send a notice to the registry that we intend to register this. And within 6 months, if they don't tell us that the utility model you want to register is already registered with us, then we are good to go. We go ahead with the registration. I don't know whether that has clarified what we mean by regional novelty.
Yeah, it has. It has, and that is very positive. And I think even in Kenya, the utility model is supposed to be national novelty. I'm sure that's what it is in Kenya. But we've had problems. I've represented my clients who have been frustrated because the novelty that people look at, they go to internet and start searching the US patent, they start comparing with my client's utility model, which ends up being a frustration journey. So I'm happy to learn that ARIPO, you are strict with the regional novelty, and I think we will encourage clients to also look at ARIPO system. I think that's very positive for me. Okay. Any other? You want to respond on that? When you were in Kenya, how did you used to look at UMs?
You know, a few things changed since we left KIPI, both of us. There's a time it was universal. I think the law still roughly says it's universal, but it doesn't specify that it has to be examined. So the Kenyan situation, in my thinking, should be very fast with registering utility models, because it only gets examined if there's a contest.
Okay.
But it's 5 years since I left, so I'm not sure that's the true position.
Okay, thank you. Okay, let's, before we are caught up with time, any other comment? You said Somalia, or there is a country you said, or South Sudan, which is a member, but it's not a member. I don't know what you meant.
It's Somalia. It's a member to the Lusaka Agreement that established our organization, but it never got around to signing the Harare Protocol. We are hoping they'll sign once they stabilize and start looking at other things.
Yeah. Anybody? Malik, do you have issues? Yeah, if you got it right, that's very good, because then the quiz will be very easy. It will be very easy for you guys. We've learned quite a lot. I'm summing up. I don't know. Before you can carry up your hand, then I see what happens. Yeah, we've learned quite a lot. I think it's now clear that any patent agent from member states, 18 member states, qualify to file for anybody at ARIPO, especially the foreigners. For example, me, I'm now being approached by, my name is prominently on the ARIPO list of patent agents. They see a full name, Frederick Omkubi Otswong'o, Biobox, Kenya. So they give me a lot of inquiry from China, US, to give a quote. And the only place they refer, I saw your name on ARIPO listings. So you guys will be very lucky. Once you become patent agents and you file at least once with ARIPO, ARIPO will be happy to list you as one of the agents, and that will expose you to the international market for patent filing. So it's a very positive move. So all we need is to go and practice. Look at the protocol, look at the national laws, and start practicing to file, especially editing the disclosure. Let me put my image. Especially looking at the disclosure before you take it for filing. I think engineer told us very clearly that it's better you look at the document before you submit, and when you are looking at it, there are issues he has brought up very clearly. And then the form must be filled very well. We have been told online is 10% discount or 20.
There
Okay.
was 20%, but we are thinking of taking it to 10.
No, please don't. Yeah, so that's an advantage, because what I do, I also go online, even if we don't have money, although it's hasara kwangu, because when you don't pay within 21 days and there is money in your account, what a report does, it scoops the money. So it's very important. If the client has no money, you can just file without paying anything, as opposed to Kenya, where you must pay the day you are going to file. And I think within 21 days you pay. So that's an advantage. And the fact that you can now play around with filing, assignment, and even litigation, I think this is a broader market for us. So I would like to thank everybody for your participation, and I look forward to more engagement. We still have 2 more courses, how to file with OAPI, the other regional office that engineer was referring to, that covers French-speaking countries in West Africa, and international filing, maybe through PCT. That one will be presented by Dr. Isaac Rottenbach. The OAPI, we have a patent agent from OAPI. We were given by OAPI itself, David Boyo, and is going to take us through on 18th of September. International filing will be on 17th. So you are all welcome if you want to learn more. And feel free to engage Engineer Miti where you need clarification. I think he's very accessible. I think I get him on WhatsApp or Messenger. We chat quite a lot, and sometimes you can call using WhatsApp.